What is a clerk magistrate's hearing? Hi everyone, Anthony Riccio here, founding attorney of Riccio Law, a Massachusetts personal injury and criminal defense law firm with offices in Attleboro and Quincy. I want to spend a couple minutes talking about clerk magistrate's hearings in Massachusetts, or what's commonly referred to as a clerk's hearing, or even just a magistrate's hearing. So I'll spend a little bit of time talking about what a clerk magistrate's hearing is, and how they proceed, and what the potential outcomes of a clerk magistrate's hearing are. So first, what is a clerk magistrate's hearing? Essentially, a clerk magistrate's hearing is an informal, or what I would consider an informal hearing, generally held in the office of one of the clerk magistrates or an assistant clerk magistrate at the particular district court where an application for criminal charges is being sought. So the way the hearing works is generally the police department that is applying for criminal charges will have an officer present, and usually it's just a representative of the police department. It's not always the police officer that wrote the report or that maybe applied for the complaint. Generally speaking, it is usually just a representative from that particular department. And usually the way the hearing will proceed is the representative from the police department will read the police report or summarize from the police report. Sometimes they may present witnesses, but more times than not, it's usually just the police officer giving a summary of the allegations, or again, reading from the police report. And again, that occurs before a magistrate or an assistant clerk magistrate, generally in one of the offices. It's not a hearing in a courtroom or before a judge. And once the police officer finishes providing the magistrate with the facts and submitting any evidence if they do so, at that point the defendant, on their own or with the assistance of a defense attorney, would have the opportunity to question the officer, question any witnesses, present their own witnesses and their own evidence. And the purpose of the hearing is for the magistrate or the assistant magistrate to determine whether or not there is probable cause to believe that a crime occurred, and in particular that defendant committed the crime. So it's not a hearing to determine whether or not the person is guilty. It is basically to determine whether or not the court is going to proceed with formally charging that particular individual. And again, the standard is probable cause, which is a much lower standard than beyond a reasonable doubt, which is needed to find someone guilty at trial. Probable cause essentially is, would a reasonably prudent person believe that there's, or find that there's evidence that a crime occurred, and in particular that the particular defendant committed a crime. And again, that standard is probable cause. So what will happen at the conclusion of the hearing is essentially there's three potential outcomes. The magistrate will find that there's probable cause and have the court proceed with charging that individual. Usually the arraignment will be scheduled for a later date, but I am aware of some courts that will actually have a defendant go into the court on that same day and get arraigned, although that's very uncommon in Massachusetts. The second outcome would be that the magistrate finds that there is no probable cause. And at that point, the case is over. The defendant does not get formally charged, and the case ends right then and there when the magistrate says there's no probable cause to issue a complaint. That may be subject to an appeal, but generally it would end with that magistrate's finding. And the third potential outcome, which is common, is that the magistrate will find probable cause, but will hold off on issuing the complaint or charging the individual. And what they will do is they'll kind of put the case on hold for, say, 6 months to a year. And so long as that defendant does not get in any further trouble, the court will not issue the charges. So it's kind of keep the matter hanging over their head for a bit of time, and so long as they stay out of trouble, the court will not issue the complaint, and therefore that person does not get charged. I personally have represented a number of individuals throughout Massachusetts on clerk magistrate hearings, and I can say that particular defense of essentially conceding there's probable cause, but asking the court not to issue the complaint can be a very effective argument. It generally will happen when the defendant really doesn't have much of a prior criminal history or no criminal history. Maybe it's a younger individual, and maybe the allegations are not the most serious. Just one last thing to consider, or that I'd like to note about clerk magistrate's hearing, is generally individuals are awarded clerk magistrate's hearing on misdemeanor crimes where the police did not observe the alleged crime. Now, there are some exceptions to that, but that is the general rule. So if you find yourself in a situation where you have an upcoming clerk magistrate's hearing, feel free to reach out to my office at 508-226-4500, and I'd be happy to meet with you and provide a free consultation. Thank you.